Welcome back to Winning Isn't Easy. Your work history and vocational experts and fighting back in your ERISA disability claim. We've been talking about the games that are played at the own occupation stage when the definition of your disability changes from an inability to do your own occupation to an inability to do any occupation. What's important in this analysis is that when you apply for your disability benefits, you're asked to complete a work history form. And on the surface, it looks straightforward. You list your jobs, you describe your duties, you explain what tools or equipment that you've used. But in my view, this form is one of the most critical documents in your claim. Why? That is going to shape the carrier or plan's entire analysis of your occupational skills. Here's one of the mistakes that I see all the time. People will exaggerate their occupational duties to make their past jobs sound more important, or they may gloss over the details, thinking that titles alone tell the story. For example, somebody may write the word manager and leave it out, the rest of the important stuff. Did you supervise 5 people, 50 people? Did you handle payroll? Did you assign shifts? Did you do any scheduling? Did you do any training? Did you do ordering? Did you do presentations? Did you do safety meetings? Just saying you're a manager doesn't tell us what your occupational duties are, which can also prevent us from understanding what occupational skills you have. I will tell you, the danger is that the carrier or plan's vocational expert, the VE, is going to fill in those blanks. And guess what? Not in your favor, because once they step in, things can get messy. The vocational evaluator, who's generally an in-house employee of the disability insurance company or the plan, is going to review that work history form. They're going to use a tool called the Dictionary of Occupational Titles, and they're going to look at the work history form and say, well, I think that this is an occupation that fits under this particular DOT code. And they make mistakes in this analysis, trying to plug it into a DOT that will allow, as they well know, for you to be ostensibly able to do another occupation because there are allegedly skills that you've learned. So they're going to look at your work history form. They're going to say, I think this may fit DOT code, blah, 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 blah. And based on that DOT code, they're going to run via computer a transferable skills analysis. They'll use programs like SkillTran. They're going to generate a list of alternative occupations that you could allegedly do in the national economy. And I will tell you, I see all sorts of crazy analysis done by disability carrier or plan VEs. They'll come up with skills that you don't have. They'll come up with occupations that really don't use the skills. They come up with occupations that don't meet your functional, physical, cognitive, or psychiatric restrictions, limitations. And then worse yet, they'll come up with numbers of jobs that aren't realistic either. But that's a different topic for a different day. So the problem here is they start out by misclassifying your previous jobs, and they may decide, for example, that your clerical role was a skilled administrative manager position, or they might misinterpret part of your job, like the occasional computer use, as a core skill that you could transfer into another industry. This is where you really need to have the assistance of an experienced ERISA disability attorney, and preferably one who has Social Security experience, because this is the game that is played in every Social Security disability claim at steps 4 and 5 of the 5-step sequential evaluation used in a Social Security case. Practically every Social Security case we try, we're dealing with these very issues. What was their past occupation? What's the DOT code? What's the preparation level? Based on these sets of restrictions and limitations, are there transferable skills? So the goal here, actually from the very beginning, but certainly in an appeal, is to challenge the misclassification of the prior occupation. We want to make sure that your work history is accurate and detailed. We want to make sure that your restrictions and limitations are clear. And that may be you getting a functional capacity evaluation, because we want to understand that your past occupation had certain skills, but that you have certain restrictions and limitations. And as a result of those restrictions and limitations, you don't have these skills, X, Y, and Z, that might transfer to other occupations. And when necessary, practically in every one of these cases where we're fighting about vocational issues, we hire a vocational expert to counter the carrier's liar for hire analysis, from the misclassification to the transferable skills analysis to all the other mistakes that the VE for the disability carrier plan makes. Now, remember, if your claim is denied or terminated, you're only going to have 180 days in which to appeal. And that appeal is not paperwork. It's your trial. It's your one opportunity to put evidence into the record to show what your past occupation was, what the skills were, how your restrictions and limitations impact that transferable skills analysis, and to destroy every job that the disability carrier's VE said existed in view of the alleged restrictions and limitations. You want to dismantle the entire flawed analysis. So please don't let vague work history forms, misclassified skills, or botched transferable skills analysis sink your case. Carriers are counting on you not to understand this issue, not do an appeal, or not do an appeal with a competent or qualified attorney is something that you need to take very seriously, because ultimately, if you are in litigation, the federal judge is only going to be able to look at what was in the disability carrier plan's file at the time of the last claims denial. There is no trial. There's no time to add new evidence. So you need to understand that making a mistake and not hiring an experienced ERISA disability attorney can be crucially fatal, if you will, to your claim. So don't make a mistake like that. Thanks for tuning in to this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our episode, leave a review, share it with your family and friends, and subscribe to this podcast. I'd love to hear from you about the podcast, because at the beginning of each episode description, you can find a little link where you can send me questions or comments. I read them, and I want to feature you in a future episode with your question. Got it? So join us next week for another insightful episode of Winning Isn't Easy. Thanks for listening.